in the case called Mahanoy versus BL versus Mahanoy. The case is going to go to the Supreme Court. They always, for some reason, reverse the party order. Anyway, and it really had to deal with the issue of off-campus speech, student speech. What are the parameters of student speech? Now, it was by no means the first case on this. There have been some lower court cases, and we're going to discuss some of them that have addressed this issue. Excuse me, but it is certainly the first Supreme Court case on it. And it's interesting, when it came down, people were, well, some people at least, in the media and stuff, were making it, sound like it was some sort of seismic change in the legal landscape. To a certain extent, I guess it was, but given the prior history, both the Supreme Court decisions on student speech and on some of the lower courts' decisions regarding social media, off-campus type speech, it was not quite as far afield as some of that precedent. Nonetheless, I mean, I think it really it's important, because it does, on the one hand gives, the other hand takes away, as is so true so often in life, as to what the powers of the school are. Quite frankly, it's there's an old saying in the law: bad facts make bad law. I'm not necessarily saying this is bad law, but they're bad facts. I mean, this is the case which, quite frankly, the district probably should not have litigated all the way up to the to the U.S. Supreme Court. Just based upon, they should have waited till they had a better fact pattern, different situation. But nonetheless, that being said, it is what it is, to quote the eminent Bill Belichick. And so before we kind of get into that, I want to sort of get into some of the background on some of the speech cases that sort of lay the groundwork upon which the Supreme Court predicated its decision. Social media is a great thing, and it's also a terrible thing. It certainly has become a vehicle by which all sorts of images and statements can be disseminated with the click of a phone, of a button, to everyone in the universe. And it has, unfortunately, to a certain extent, encouraged the worst instincts in some people. They talk about the fragmentation of society, atomization of society. You have kids who refuse to come to school avoidance, which is one of the leading issues that has been now for some years. I mean, I spoke on school avoidance to the National School Board Association back in 2013 out in San Diego, and it's still an issue. Perhaps not as pronounced as it was then, but it's still an issue. And it's, part of my own totally unsubstantiated belief system is that social media has led to this, because now people can communicate without being face to face. Their communications are so geared toward the personal devices and toward the internet that when they have to actually come face to face with people, rub shoulders with their peers, it becomes too much for them, or so they claim. I'm a board attorney, so call me a cynic as well. Anyway, but one of the interesting issues on social media is that, and part and parcel of what I just talked about, is that it generally happens off school grounds. When people are promulgating some of these images and words, it's typically not happening in school. It's happening at home, at night, on the weekend, off school grounds. Sometimes it can be difficult to know who wrote or disseminated the threatening or offensive behavior, the words, the images, which kind of sometimes leads to a little bit of anonymity and really makes it very difficult for school districts to know, well, where do we go here? Who do we speak to? And given that in the era of TikTok and Jackass and so forth and so on, where people do and say stupid things because they're kids, they sometimes it's hard to know, should I take this seriously? When did the social media post require prompt action, even if I haven't obtained all the facts? Um, Let me give you an example just from the get-go. It's a case I in fact had. Um, a student, high school student, this was a few years ago, not too many, but a few. The high school student, and he has, let's say he has had a checkered career. Um, and one night he posts a video, and this particular student has expressed pretty extreme views, um, fairly antisocial type views, and he posts a video, and he's holding a gun, and across the screen, he doesn't say anything, but across the screen is warning, warning, warning. Keeps going across the screen. Well, he posts this on social media. Kids see this. They know of the student's particular proclivities for, again, anti-social type behavior, and they understandably freak. Tell their parents. The parents call the school district, and the school district contacts the police. They don't say, well, okay, I tell you what, we did see this video, but we're going to take some time. We're going to conduct a full investigation, and then we'll decide whether we should do anything. And in this case, I thought it was totally appropriate. I mean, here's a student, again, he's got a history, and he's got a gun, and it's just saying warning. Now, he never says, I'm going to come in and shoot up the school. He doesn't say, I'm going to come in and target anyone in particular. But there's a constellation of facts there, where the fact that it's kind of this kid's history, the fact that he's known to be very critical, very profanely and intensely angry at some certain groups within the school, and now he's got a gun and it's stating warning. So there's a situation where administrators are suddenly forced to make kind of split-second decisions. What do I do here? And in this case, I contacted the police, and the student was suspended. And of course, the parents later say, well, he didn't mean anything by it. It's perfectly normal for kids to be holding guns and posting videos with the word warning. So these are difficult situations that administrators find themselves in. Ones that this is not your father's or your mother's school issue anymore. This is a completely new phenomenon. So, districts find themselves, they're in a position where they have to balance free speech rights, because sadly, students have free speech rights. And at the same time, their number one obligation, in addition to providing an education, is to make sure that education is being provided in a safe environment. And so so these cases really all are predicated upon the First Amendment of the United States Constitution. Connecticut Constitution has a comparable provision, but it's a First Amendment case law, which really is the guidance here. And as I've quoted the First Amendment, and I love using colored bold font. Any of you who have been through any of my prior presentations know that about me. The abridging the freedom of speech. We're not talking about freedom of religion here, or peaceably to assemble, or to redress grievances to the government. We're talking about the freedom of speech provision, which is probably the provision which is the most well known from the First Amendment. And you're also faced with the fact that you have parents who, and like they say, you depend on their perspective. Some will say they're champions of free expression. Others say, good God, these are the worst enablers, the mothers of all enablers. I mean, you have parents who on many occasions have literally made a federal case out of disciplinary actions. What, the child's going to be suspended? Now remember, in Connecticut, you can only be suspended for up to 10 days. So my child is going to be suspended for possibly up to 10 days. I am going to federal court and making an issue out of this. That's a lot different. I mean, I'm not telling you anything you don't already know. That's a lot different from back in the day, when I would not have been stupid enough to tell my parents that I got in trouble at school because I get into even more trouble at home. So you do have these parents who will really go to the mat, spend the money, and go to federal court to try to eradicate this discipline or get it rescinded. Now, some of these cases have reached all the way to the United States Supreme Court. The Supreme Court is presented with so many petitions. There are multiple federal circuit courts of appeals across the country. We're within the Second Circuit. New York, Vermont, Connecticut, we're all within the United States Court of Appeals for the Second Circuit. They sit in Manhattan. I've argued there a number of times. It's always pretty cool to go down there and do that. And then these cases, people will try to petition for certiorari, which basically is a fancy Latin word for saying, hey, Supreme Court, would you take a look at this case? We think the appellate court got it wrong. The court, U.S. Supreme Court, takes just a fraction of these cases. And frankly, in about the last 15 years, 20 years, they've taken even fewer than they used to take. So for any of these cases to reach the U.S. Supreme Court, there often has to be a conflict among the circuits. One circuit is held X, the other circuit is held Y. And it's an important enough case for the Supreme Court says, okay, we got to resolve this. So there really have, prior to the BL case, and I'm using the original, case caption, prior to this case, there were really only about 4 cases. There are landmark cases in the area of school law that made their way to the Supreme Court regarding speech. The first, and perhaps the most famous of them all, was the Tinker versus Des Moines case, all the way back in 1969, 52 years ago. And it had it resulted in one of the most famous phrases in Supreme Court jurisprudence: students do not shed their constitutional rights to freedom of speech or expression at the schoolhouse gate. This was the case that really established that students do have free speech rights. Now, they're more limited than we as adults have, but nonetheless, they have some. This was back 69, back in the middle of the Vietnam War. Some kids wore black armbands to protest the Vietnam War. They weren't holding a rally. They weren't shouting, hell no, we won't go. They weren't doing anything like that, but they're just wearing these black armbands. The country, ridden at that time as it was over the Vietnam War, there were a lot of people who felt that this was totally inappropriate. And the school administration here was some of those people. And I'm not saying they're right, I'm not saying they're wrong, I'm just simply trying to explain the context. So they suspended these kids. And they litigated this case up to the US Supreme Court. And the court said, as I said, they just noted, students have the right to freedom of speech. Now, there are some limitations. And the court held these expressions of speech are permissible unless they materially and substantially disrupt the operation of the school and or could be reasonably expected to do so. So let's say these kids, instead of wearing black armbands, had decided to have a sit-in. We're going to sit in the school, we're going to shut this school down, or we're going to, get the kids to walk out of their classes, and we're going to have a rally. Okay, well, that would clearly be a material and substantial disruption of the school, of the educational process, which is the phraseology that's used by Connecticut state statute. But this wasn't the case. This was just cases of kids walking around with black armbands. The court said there was no disruption. It was simply business as usual. It's just that kids, again, were wearing these armbands. So that was really this landmark case. And then really nothing else came down the road with respect to free speech in schools until 17 years later in Bethel School District versus Frasier. So you get some wise guy student who's giving a speech in a school assembly. Around approximately 600 students are there. And the purpose of this speech is to nominate another kid for class office. Well, this kid decided he was going to be oh so clever, and he inserted within his speech all the sexual innuendo. sexual innuendo, which was pretty obvious. It didn't need someone versed in Master than Johnson to understand what he was saying. So the district suspended the student. Totally inappropriate conduct. They say they suspend him. Supreme Court, in this case, back to school. And this court held that vulgar speech and lewd conduct wholly inconsistent with the, quote, fundamental values of public school education. It was totally appropriate. How is that? The school has to be able to maintain a certain amount of order, a certain amount of expectations. Now, that's not to say that this kid made this speech with sexual innuendo and people went wild, and went crazy, went running up and down the halls or anything like that. But it's just the idea that you can't reasonably expect a school to be sitting there and saying, oh, okay, our students making all these inappropriate sexual assertions, making these kind of smutty, lewd, vulgar comments, and fine, whatever. He's expressing himself. That it's perfectly reasonable for the school to say you can't be doing this, because then it becomes a slippery slope. Where do you stop? Where do you stop this? So, although the Supreme Court basically established a different basis. There's the materially substantially disrupt, but they also said the school has the right to implement its fundamental values, public school education, which do not include making lewd and vulgar comments to students. Someone has asked a question, and I'm going to get to this a little bit later. You're going to hear me say that a lot, but I am going to get to this later about what are the criteria for substantial disruption, material and substantial disruption. I'm going to talk about that, as I said, a little further in these slides. So, the schools win. There's joy in Mudville. As a school lawyer, we're feeling very happy. I mean, I was not I wasn't a lawyer yet in 1986, but nonetheless, in looking back on this case, as a school lawyer, I'm representing school boards, where I'm thrilled and pleased with it. 2 years later, 2 years, remember 17 years between the first two cases. Now, 2 years later, Supreme Court takes up another case. And this is a school journalist, inspired by Woodward Bernstein. They're going to do these articles about teen pregnancy in the school, and also about a divorced family, which is kind of peculiar, but nonetheless, the article about teen pregnancy actually includes information about students at the school. Administration said, absolutely not. You cannot write these articles. You cannot publish these articles. Again, this is all before social media, so this was the old-fashioned print approach. Works its way to the Supreme Court. Supreme Court says, suppression of student speech was reasonably related to legitimate pedagogical concerns. Some of those pedagogical concerns involve, the privacy of the students involved, in the fact that this would, expose some students to unwanted attention, and quite frankly, maybe nowadays we're talking 33 years later. Maybe nowadays it would be a different ruling. Maybe there would be more of an argument that this is really a kind of a safe sex preventative type approach. Articles like this, these are cautionary tales, or even more so that these are what some of your peers are dealing with. You need to be sensitive to them, so forth and so on. But at that time, they said, the district had this reasonable belief that this was going to be contrary to the pedagogical standards, and was going to, again, involve invasion of privacy and that sort of thing. Finally, the last of the four cases back in 2000, this is before the BL case, Morse versus Frederick, 2007. So now you've had 19 years go by again between these types of cases. I'm sure you've all heard of this. I always get kind of a kick out of this. They're having the Olympic torch relay. So the school is having students line the road. It's a school-sponsored event. It's it's this celebration of the fact that the Olympic torch is being brought through their town. And so some kid decides to use this occasion to unfurl this banner that says "Bong hits for Jesus." The school is less than pleased with this commentary on the use of illegal drugs and suspends the kid. Once again, school district prevails. The Supreme Court held that the district had a compelling interest in prohibiting speech that could be reasonably construed as promoting or endorsing the use of drugs. You get some knucklehead out there holding bong hits for Jesus. Is he necessarily endorsing the use of drugs? Yeah, I guess he is. But, a little bit of a stretch. But nonetheless, the school understood, and again, here's where the administrators are put into a tough situation, because are they just supposed to chuckle about that? Say, yeah, that's right. Bong hits for Jesus. What a character that guy is. By not acting, it's almost this kind of implicit endorsement of and acknowledgement and endorsement of drug use in the school. And needless to say, no administration in their right mind wants to be seen as endorsing that. So, they did discipline the student, and the Supreme Court said, hey, perfectly appropriate. A school district doesn't have to sit on its hands and allow people to be essentially proselytizing for the use of drugs. Now, what do these Supreme Court cases all have in common? Well, they're all on school grounds during the school day. Bong hits for Jesus across the street, but nonetheless, it's immediately adjacent to the school. It's during a school-sponsored event during the school day. So, same difference. And so, based upon the Supreme Court precedent, it was determined that schools have the greatest ability to regulate speech that is violent or disruptive. Now, Tinker was not violent or disruptive, but in the decision, the court essentially said that if it had been a disruptive, violent, what have you, then the school would have had the right to take the disciplinary action it did. Vulgar and lewd, they can control that occurs during the school day, or speech that is contrary to or at odds, with the pedagogical mission. Again, a district is not required to endorse student speech during the school day, school-sponsored events, which is promoting drug use, seem to be promoting students having sex, that sort of thing. That's not part of the pedagogical mission. But with the advent of social media, so much more of the speech has started to take place off school grounds. And that created this sort of new dimension to what was fairly settled law. So what do we do with this? These are what they call cases of first impression. And, the courts and the parties had to grapple with relying upon, can we regulate speech that is off campus? So essentially, what courts have done, they've relied upon Tinker, all the way back to Tinker. And they've allowed districts to regulate off-campus speech if the speech is reasonably foreseeable to cause a substantial disruption to the school environment. In other words, it either does cause a substantial disruption, or it was reasonable for the administration to believe that it would cause a substantial disruption. I think that in the law, and I'm not going to get too far, I don't want to get into the weeds here, but there are, when you're a first-year law student, you take a course called Civil Procedure, and one of the things you learn about is your court jurisdiction, which is fundamental to any court action. And sometimes matters have happened by individuals or entities that are outside the state, and there are certain ways in which the court can nonetheless still get jurisdiction over them. It's called long-arm jurisdiction. And this is sort of the same kind of idea, this kind of long-arm ability to regulate the speech that occurred off campus. Not because they're the roving moral police or anything like that. And as we'll see, as we discuss, there has to be a bridge. There has to be a connection where this off-campus behavior leaks into the school day and is going to cause a substantial disruption there. So there has to be a nexus. There has to be a connection between the off-campus speech and what happens during the school day. But as I say, tinker again was decided decades before the advent of social media, which has taken speech to areas the court could never have anticipated. So as I've said before, the students can now swiftly and extensively promulgate threats and harassment. All right, I have the spelling there. Yeeks, and I was an English major too. Sorry about that. So I've already talked about this. It has to cause a substantial disruption. You're undoubtedly sick of hearing the term substantial disruption at this point. Now, this kind of ties in with the Connecticut law. 10-233D of the Connecticut General Statutes, it provides that a student may be expelled for off-campus conduct if two criteria are met. The conduct violated a publicized policy of the board, which conduct on school grounds or the school-sponsored activity also obviously has to violate a publicized policy of the board, and the conduct was substantially disruptive to the educational process. There was a case called Kyle Packer versus Thomaston Board of Education. It came out, oh God, at this point, 20-something years ago, in which the state Supreme Court held that conduct that occurred off school grounds was not disruptive of the school day. I mean, they said, hey, it happened off school grounds. Kid had drugs. He's off school grounds. How did this disrupt the school day? How did this have any interaction with the school day whatsoever? So the legislature amended 10-233D to set forth certain criteria for when off-campus behavior can be seen as substantially disruptive of the educational process. And it includes if more than one student is involved. So let's say you have a couple of students off school grounds who are, taking drugs or engaging in criminal misconduct. Well, there's more than one student involved, so that's one of the criteria. Another one, if it involves gang activity, if it involves violence or threats of violence, which would seem to encompass some of these cyber based, social media based misconduct, and or whether it took place in close proximity to the school. So I have prosecuted roughly 1 million student expulsion hearings in my career, either prosecuted them or served as a hearing officer, or if the board was hearing it, served as a board procedural advisor. So, you'll see these off-campus behavior cases, and substantial disruption is quite frankly given a very loose general application. Well, Principal so-and-so, were you there on that day? Yes. And was there or did you become aware of this off-campus behavior? Yes. And did it result in an investigation? Yes. And what did the investigation entail? Well, we had to talk to some students. We had to conduct a thorough investigation of what had been posted or what we learned had occurred off school grounds, talk to different students. And did that detract from your performance of your regular duties as principal of the school? Oh, absolutely. I had to spend time running down witnesses, talking to witnesses. And typically that passes, that's enough to get over the threshold of whether it's substantially disruptive to the educational process. Now you're going to see some of the federal cases we're going to talk about. The federal court might not always agree that substantially disruptive, that would satisfy, the example I just gave would satisfy substantial disruption. But again, the standard practice in most expulsion hearings, obviously I have not been participating in every expulsion hearing ever held in the state, but I've done many over the years in different capacities. The only capacity I haven't done it in is defending a student, but I've done every other capacity. And that typically is sufficient to be substantially disruptive to the educational process. So when someone's asking what the criteria is, I gave you the statutory criteria. And again, it really is if let's say well, let's think about this. Let's say you call the kid in and say, Billy, and you have to do this before you suspend the kid anyway, under section 10-233C of the Connecticut statutes and under, under Supreme Court precedent, the kid had the due process right before he is suspended. That due process right, unlike an expulsion where you have a full hearing and they can introduce evidence, a suspension due process essentially, you call the kid in his office and say, Billy, did you do this? No. Okay, you're suspended. You let the kid give his side of the story. But so if you just call the student in and say, Billy, did you engage in a conduct? Yes, I did. It was me. I did do it. And I did this. I, was involved in a drug transaction. And actually, let me digress for a moment. One of the criteria too for off-campus behavior being substantially disruptive, this is kind of bizarre. It's if there's the use of alcohol. It doesn't talk about the use of drugs, which makes absolutely no sense to me, but typically they're treated the same. So yes, or I was drinking off campus, let's say, so let's go with that. I was drinking off campus. All right, well, you're suspended. Okay, it's a substantial disruption to the educational process because it falls within the criteria of an involved use of alcohol. But as far as disrupting the school day, it really didn't. So even if it doesn't involve, the investigation and the principal and assistant principal having to devote time to some sort of full investigation, if it fell into like the use of alcohol or drugs, that under state statute can be substantially disruptive. So, hold on a second. Another question, how did this apply with summer vacation? It's summer, it's hot, kids are bored. They're sick of being stuck at home through the pandemic, so they engage in misconduct. That really is far more attenuated. It is difficult. Now, if they get, you get a notice from your local police department saying that he engaged in a felony, and it's a violation of board policy. If it involved violence, I could think you could still make that argument because again, that's one of the criteria that's set forth in 10-233D for off-campus behavior. He beat the bejesus out of someone else, especially with another student, well, then definitely. But if it was just some sort of off-campus behavior that really, it really would be more difficult to show. It's the summer. By the time school comes back into session, unless this happened the week before school resumed, it's kind of one of those situations that, well, how is this disrupting the school day? It happened in June. It happened after the school year ended. It happened in July. It happened in early August. That would be a more difficult correlation to draw. Now, if it involves something heinous like violence or sexual assault, something like that, I'm always of the mind that, you know what, make your case. You don't want the kid in the school for that kind of behavior. And if later it's found to be, well, really with a substantial disruption, hey, you know what? You are acting to protect the safety of the school. So I'm a little more aggressive on those types of things because I think ultimately you have an obligation not only to protect the rights of that one kid, but also the rights of everyone else. And those rights include the right to have a safe environment. But for the most part, if involved a guy smoking dope, something like that during the summer, it would really be far more difficult to, or bullying, one kid bullying another kid over the summer, unless you can really establish that that's going to carry over into the new school year, and that becomes really speculative. That's a hard connection to draw. Great question. I mean, that's an excellent question. But I think you'd be on far more tenuous ground there. Okay, this right, I think implicit in my words has been this: the right to discipline for off-campus behavior is not without limits. Okay, so we're going to talk about some cases here. Identifiable threats of violence. Kid sends an instant message to a friend with a picture of a person firing a gun at his head, picture of splattered blood. Under it says a message, kill Ms. Smith. I'm just obviously just substituting a name in there. He sends a message to approximately 15 of his IM buddies. It spreads like wildfire. Also reaches the teacher and the school administration, although the student subsequently claimed it was meant as a joke. The student was suspended. Parents file suit. My poor child, how could you do this to him? He's incredibly gifted and you're impeding his expression of creativity. School won. And the court said that we conclude it crosses the boundary of protected speech. And it's true. Free speech doesn't apply to all speech. Number one, it has to be out public. Typically, people have the ability to speak publicly, but if you're threatening or engaging in obscenity, that's not protected. But it posed a reasonably foreseeable risk that would materially and substantially disrupt the work and discipline of the school. Because it came to school authorities, the school now thinks, oh my God, we've got a credible threat here. Maybe this kid's got a checkered past, just like the kid I talked about in my case. And this was disseminated to 15 kids who in turn disseminated it. So the court appropriately held that there was a reasonably foreseeable risk and that so it was appropriate for the school to suspend the kid. Now, however, we have Berg versus Colton, BOE. And the student was angry at his teacher for giving him a C. Now, as we all know, students, I got an A, I earned an A. The teacher gave me a C. That's how it always goes. So he gets a C because no child in Connecticut is average. Obviously, this didn't take place in Connecticut, but it's true with other states too. So they get a C. We post on his private, and that's the key word, private Facebook account that the teacher should be shot. Only his Facebook friends, and this is a private account, could view the post. Nonetheless, an anonymous student brought the post to the school. Once again, the student meant to post as a joke. These kids are laugh riots. But the teacher, the subject of the post, was legitimately frightened. Oh my God. So they suspend the kid. They go to court. And who wins? The student. What the hell? The court noted the lack of an actual disruption to the educational process. Now, remember, these things aren't being decided in a vacuum. There's facts and evidence that's being introduced. And the evidence demonstrated there was no widespread whispering campaign, no students missed class, no district employees, including the teacher, missed work. The teacher understandably protested having the kid back in our class, but the school said, it's got to come back. And she said, oh, well, okay. And there was no further discussion about it. And so the court held district overreacted. Now, I'm sorry, I put Burgos, which instead of Berg, that was a kind of a Freudian slip. Burgos is a federal case that I litigated years ago, successfully, I might add. So I kind of had a flashback there for a moment. Anyway, the disparate outcomes of the two cases underscore the fact that these cases, there's no blanket approach to them. They are really considered on a case-by-case basis. And there's certain nuances. Now, in Wisniewski, there was a widely promulgated threat that reasonably posed a risk of a material and substantial disruption. And remember, this kid takes the extra step to post a picture of someone getting, being shot, blood, it really makes a pretty explicit threat. Berg, however, was more passive. You can see the teacher should be shot, in his private Facebook account. It's essentially like he's musing. He's thinking aloud. Damn that teacher. And it was only intended for the students' friends. It wasn't meant to, really be an active threat. Now you might be saying, Mike, you're really engaging in semantics here. Well, I didn't. This is the court. But these are different courts. But essentially, that's the justification. The kid is making a random comment on his private Facebook page. The evidence adduced by the district did not show any real disruption. Now, needless to say, school became aware of this and investigated it. So you're thinking, hey, Mike, you just told us that under 10233D, you go to these expulsion hearings and there's evidence of an investigation, and that's sufficient to constitute substantial disruption. That's true. But as I also noted, sometimes the federal courts don't see it the same way that the state statute does. That, this widespread investigation or an investigation is not in and of itself sufficient to constitute disruption. But again, so they're case by case issues, and that sounds like, oh God, lawyer cop out language here. Well, have to look at the specific case. But yeah, that's essentially the truth. You have to look at it a case by case basis. And again, when we're talking about investigations, a lot of times it really does involve it's far more involved type of situation. I think the Wisniewski case was appropriately decided. The Berg case, well, again, I wasn't there, but I mean, given the evidence that there really was no disruption, there wasn't some widespread discussion, students weren't in fear that somebody was going to come in and shoot up the school. It was sort of like thinking aloud. Remember, the great transcendental poet, American poet, Ralph Waldo Emerson, he referred to a friend as someone with whom I can think aloud. Now, I'm not comparing the student to Ralph Waldo Emerson, obviously, but the student is essentially thinking aloud on his Facebook page, his private Facebook page, so it's not really an active threat. It's more like a screw her kind of thing. And I think that's how the court saw it. Okay, hold on a second.
Excuse me, Mike, before you move on, there are a couple of questions, I think, on that last case that both talk about the teacher involved.
Right.
And the first question, why would the teacher not have discussed the matter with the student? And the second, what recourse would the teacher have if the teacher felt threatened? What weight does that have on the case?
Well, I think the first, I think that's very speculative on my part. I think the teacher would have talked to the student because she probably was told, don't make an issue of it. This is how it is. Just move on. We have determined that there is no threat to you. And, that the teacher basically wanted to move on, did not want to make this an issue. Excuse me. So, I think that's essentially what it was. I just think that might have been a part personal choice part. Maybe the administration said, you know what, this is how it is. He's got to come back into your classroom. We made a determination that the student is not a threat. And so he's back in your classroom. If the teacher still feels threatened by the student, well, again, the administration is determined, and very often, in a lot of cases like this, what sometimes schools would do, they'll get a threat assessment, and they get someone to assess the situation, talk to the kid, evaluate the kid, and see if he poses a risk to himself or to others. And if they say, no, this kid was just thinking aloud, he really is mortified, he has no desire to hurt anyone, then he's back in school, and essentially it's filed under stupid inappropriate kid. And we have made a determination as the administration at the school district that he does not pose a threat. And therefore, you need to keep working with him. And then if the teacher gets really stressed out by that and really feels maybe she can't perform her duties, well, that's a completely different issue. But I think it would be ill-advised for a school district to simply put the kid back in the school class, say, here he is. I think that they would have to make some sort of reasonable assessment to determine whether or not he did pose a risk. I think you'd want to do that for pure liability purposes. And I think you owe that to, your teachers, to be aware of their reasonable concerns and address it. Okay, reasonably perceived threats of mass violence. Student poses a video of a kid shooting other kids. He had been bullied, and now he decides to shoot others. It was developed by families of the victims of the Sandy Hook shooting. So it wasn't obviously for sensational purposes, but rather to underscore the dangers of bullying and what the consequences of that can be. So this individual posted it on a private social media, this video, but he also added that violent lyrics of the video when he posted it on his website. It was suspended. So he just didn't post it by itself. He also had these violent musical lyrics. So the school was closed for a short while after it came to school attention. I mean, they were alarmed enough that this kid is basically saying, this is what's going to happen. Parents filed suit, and the school won. The school district closes. Buses in the school district are canceled. All students and parents are messaged saying, you know, we have an incident, we're investigating it, school will be closed. You know, clearly that is disruption. That's a serious, substantial disruption, and appropriately so. So the school prevailed at that one. So again, this is disruption. Another case, did school won again, in that kid said, you know, he talked about, so was sending a string of increasingly violent messages, bragged to the weapons he owned, threatening to shoot specific classmates, saying he'd take out other people in school shootings, cites Virginia Tech massacre. The kid does all this. The school appropriately suspends and disciplines him, and the parents file a federal lawsuit. I mean, come on, earth the parents. And the court ruled in favor of the school. As they say, we can only imagine what would have happened if the school officials, after learning of the rioting, did nothing about it, and the student did come to school and shoot up the school. So this is all kind of a common sense kind of thing. I mean, this kid is sending increasingly violent messages. And again, it's a case-by-case determination. And in this, the district acted appropriately because this seemed to be escalating. People were getting concerned that there's going to be a mass shooting at the school. So there was, again, once again, a disruption. Okay. Talk about, again, I'm going to get to the BL case, but I just want to kind of give you the groundwork leading up to it. Cyberbullying cases, created a MySpace page called Sash. You can see for yourself what it stood for. Picture of female victim student, before referred to as a whore and other hurtful comments. 24 students from the school posted comments on the site. So the parents of the victim complained to the school. School determined the kid had created a hate website, which resulted in a suspension. Who won? Well, the school did. And this really kind of goes back to the Frasier Hazelwood, the Frasier versus Bethel case, in that this is not content and speech that schools are required to tolerate. They're trying to educate students about habits and manners of civility. And some of the factors considered by the court were that the dialogue on the webpage took place among students at school, who the student invited to join, the one who created the webpage. And obviously this reached the school. Kids are all plugged in. They're all on social media. So the fact that it happens off school grounds, it's not like it comes to the school and suddenly they have no access to this, or suddenly their minds are wiped clean. So obviously it's going to spill into the school. The comments were made specifically about the victim student, not people in general. And it was just, it caused an actual or nascent, which is kind of interesting, substantial disorder and disruption in the school. I mean, you got all these kids, ganging up on this one identified student in the school It's happening off school grounds, but then she's got to come in. People are talking about her. People are talking about it. The parents are coming to complain. The kid is understandably upset. It's adversely affecting her ability to access her education. And so all this has all occurred off school grounds. This has leaked into the school. More than leaked, it's poured into the school. And also keep in mind the fact that the whole purpose of this kid, what a nasty piece of work that she specifically went to the effort to create this internet space, the social media, MySpace, and just to target this kid. And she's, come on, what do people have to say about her? And egging on other kids to pile on and to target this one kid. That's clearly bullying. That's clearly the whole point of it is to make this kid's life a living hell. The common nexus among them is school, and this is carrying over to school, and it's starting to get other kids in the school involved because they're weighing in. Other kids are seeing it. It's clearly the schism between school and out of school has joined, and it's almost inextricably entwined. And so the court appropriately held that, you know what, district had the right and the obligation to take the disciplinary steps that it took. Of course, I think you've seen the pattern by now. Whenever I talked about the first case, the school wins, second case, the student wins, and that's here as well. This is, and you're going to say, well, what's the difference between this one and the other one? Well, for one thing, this is a kid who basically, she's, once again, it's sort of like the Facebook page, what the kid was doing. My teacher should be shot for giving me a C. Once again, the Emersonian thinking aloud with a friend. The student records herself and her friend at a restaurant talking about a female victim student. She's a slut, she's spoiled. So basically what they would be talking about if the camera wasn't running, they're talking about with the camera running. And, you know, then she posts the video to YouTube and tells other students from the school, including the victim. Nice kid. Hey, Janie, you might want to go to this YouTube channel. You might find something interesting there. And so they go to it, and student starts to cry, misses some of her classes, goes to the guidance counselor, and suspends, interviews, the school administration interviews the students who were in the video, and suspends the student who made it. Students used to school. Student prevails. And now you're going to say, well, now, once again, Mike, you said under Connecticut statute, if they do an investigation, that often will be sufficient to constitute substantial disruption. Well, yeah, under 10 to 233D, it will. It's generally held to be. No one's really put that to the test, but in court, but typically that's what happens all the time. Here they investigated it, but you know, the court held the video was not violent or threatening. Victim never feared she was going to be attacked. She felt embarrassed, her feelings were hurt. And the victim did not confront any of the students who made the video in school. It took about 20 to 25 minutes for a guidance counselor to calm the student down, and she went to class. They took time to investigate and counsel the victim, but you know, the court somewhat dismissively said, well, that's what school administrators do. So that would seem contrary, directly contrary to the expulsion statute determination of what constitutes substantial disruption. I don't know if I necessarily agree with the court on this one. You know, what am I on but a mere lawyer? And this is the judge. And you know, one of the things you have to keep in mind, a sad fact of life, is that I can sit here and say, well, you know, the differentiation here is because, you know, in this case that happened, in this case that happened. But also one of the really big issues, or one of the really big factors, is who the judge is. You know, I do a lot of special education as well. Not so much the case anymore, but in the past, some years ago, there used to be certain hearing officers who, if they were assigned to your case, you thought, oh my God, my case just got a lot harder. Whereas, and there are other here, in fact, there's one in particular, I had two separate parent attorneys, two separate hearings, when this one hearing officer was appointed to say, hey, Mike, my case just got a lot stronger. And I knew exactly what they meant. Then there were other hearing officers who tended to look at the cases more objectively, often sided with the board. Well, the same is true with judges. Some judges, judges, they apply the law, but they also bring their perspective of the law to the cases. So you might say, this seemed indistinguishable from the other case. Well, they had different judges. At the same time, the other one, this is kind of weird. Back in the day, these kids would have been sitting here at a restaurant talking about their fellow student. And then one of them might have said, hey, to somebody who wasn't there, did you hear what Jamie said about Mary? Oh, really? And then that person tells somebody else. Now they don't have to do that anymore. They video it, they put it on YouTube for all the world to see. The difference might be that they are not encouraging other students to pile on. They're not saying, hey, what do you think about this kid? And really egging other people on. They're just sharing their thoughts with the world as if the world cares what they have to say. And unfortunately, they file suit, and this kid's opinion of the wisdom and insight of her own words is kind of given credence by the court. But essentially, the court says, you know what, the fact that student A says something and student B takes offense, that's not enough to suspend a kid. Again, there's no threats of violence. There's no attempt to egg on other kids to really pile on this kid. They just, basically said, I think this kid's a jerk. They post it online, and they don't go through this whole elaborate setup that the other kid did. So as this shows, again, this is the case-by-case determination. There are nuances sometimes. They're close calls, and that's, I'm not saying this because I'm a school attorney, but I mean, that's why you talk to your attorneys and say, these are the facts, what do you think? And I'll tell a district, hey, I think you should move for an expulsion. Other case, I'll say, I just don't think you have enough here. The kid's a jerk, but I just don't think you have enough. So that's essentially the difference. Someone had asked that one of the issues might have been the fact that the grounds used to suspend the student, substantial disruption, were there other grounds which could have been used. And yeah, I mean, well, typically, that's a good question, but I mean, typically, what the courts have predicated these decisions upon is that substantial disruption. Is it causing substantial disruption? In this case, and then there's another question asking, what if they had used hate speech? What if they had used like racially charged hate speech? What if they had said, hate crime speech directed towards a student? Well, unfortunately, the Supreme Court held in a Minnesota case, not involving schools, about 20, 25 years ago, that, hate speech can also be protected speech. So, yeah, I mean, I think that would give you more grounds, because it could be seen as making a racially charged environment, and could lead to disruption, both with respect to retaliation against the person who made the statement, as well as maybe an encouragement of a racial or sexual animus. So yeah, you might have more of a case here, but again, it's a fact-by-fact basis. You can't just say, well, I used hate speech, okay, that's it. You've got to show, was there a serious disruption? Was it more than just a student being understandably offended and understandably upset? And now, again, that's what it all keeps coming back to. I told you you're going to be sick of hearing me use that term. So now we finally, in June of 2021, come to Mahanoy versus BL, which is the Supreme Court caption. Now, I kind of got a kick out of this case to a certain extent, because some years ago I had a lengthy special education hearing brought by, it was just beyond bizarre and should have been dismissed, but the hearing officer, I mean, I know it ultimately prevailed, but the hearing officer made us go through a hearing. And it was a girl who's on the dance team at the school, and she had been like one of the student leaders of the dance team. They got a new coach who basically said, "No, I'm in charge here, not you." So the parents were outraged, and claimed that because this kid had an IEP, that this was disability discrimination. It was ludicrous, but nonetheless. So here's the same sort of situation. Here you have BL. She tried out for the school varsity cheerleading team, did not make the varsity team, but was offered a JV spot. She also did not make a private softball team. To quote the court, BL did not accept the coach's decision with good grace, particularly because the squad coaches had placed an entering freshman on the varsity team. So then over the weekend, BL, she's using her smartphone, post a couple of photos on Snapchat. And the first image shows BL and a friend with middle fingers raised and bore the caption, F school, F softball, F cheer, F everything. Needless to say, she did not stop at F, but added the next 3 letters as well. I just decided not to use them here. And the second image was blank, but for a caption that read, "Love how me and this other student get told we need a year of JV before we make varsity, but that doesn't matter to anyone else." And it has an upside down smiley face emoji. So somebody, brings this to the attention of the school coaches. Coaches decide, well, hey, if they post-use profanity in connection with the school extracurricular activity, that violates team and school rules. So she's suspended from the junior varsity cheerleading team. The kid subsequently apologizes, mea culpa, but it essentially told to go pound sand. So then, they appeal to the AD, the athletic director, the principal, the superintendent, the school board. They all say, "Nah, you're suspended." So, but of course, the parents filed a federal court lawsuit. Now, I snarkily say, but of course, but I guess they knew what they're doing because they went all the way to the U.S. Supreme Court and they ended up prevailing. The interesting thing is, however, is that it was kind of the Supreme Court's decision, and I'll expand upon that in a moment, it was kind of a good news, bad news kind of thing. Because this Third Circuit, remember I told you the country is divided into different circuit courts of appeals, and the Third Circuit issued this kind of alarming decision, essentially said that, hey, schools can't regulate off-campus student speech. The hell with them. Off-campus, you're at a school outside your boundaries. Well, that it's kind of stupid, quite frankly, with all due respect to the learned members of the bench there. And the Supreme Court said, no, the Third Circuit is incorrect to the extent that it issued this blanket limitation on a district's right to regulate off-campus speech. And it's so this is, in a way, this is kind of a win for school districts. Everybody said, "Oh my God, this is school districts. The world is ending. It's apocalypse now." But actually, it was, in a certain extent, it was a win for districts because they said that schools, being schools, that they have a certain license to regulate student speech. All the way back to cases 30 years ago, 20-something years ago. And it does not disappear when a school regulates speech that takes place off campus. So in other words, it affirmed that a school district can discipline students for off-campus speech. Now that's a big win. Other lower courts had held that, as we've just discussed, but this is the U.S. Supreme Court. So that was kind of lost in the shuffle when the media was reporting this. Did not quite fit into the soundbite. So the court recognized, again, it's like this long arm kind of jurisdiction the school has off school grounds. And it said it remains significant in some off-campus circumstances. Serious or severe bullying or harassment targeting particular individuals. Well, here we have that Sash case we were just talking about. Threats aimed at teachers or at other students. The failure to follow rules concerning lessons, writing of papers, so forth and so on. Things that occur or at least originate off campus. I mean, the Third Circuit's perception ruling was just insane, quite frankly. And the court said, well, wait a second. You know, you got severe bullying or harassment. You've got threats aimed at teachers and students. Of course, the school can take action. However, it's not without limitations. And this is where this is where things start turning. This is where the child still, picture a child smiling, delighted face at an ice cream cone in the middle of summer. And then continue to watch a child's face as the ice cream cone starts to melt in the heat. That's sort of how this case decision devolves. So the court goes on to observe that while it could, their disciplinary purview does extend to off campus, it's more attenuated. So off campus, the leeway this First Amendment grants to schools in light of the special characteristics is diminished. The special characteristics, that's like a referral back to the ability to protect against substantial disruption, to protect against threats, to foster the appropriate pedagogical interests. So you do have the right to discipline for off-campus behavior, but it's not as strong a right as you would for on-campus behavior. Now, let's take this student. Let's say the student says, let's say the student goes to let me go back to get her exact eloquence. Let's say she's on school grounds. Let's say she's the coach, F school, F softball, F cheer, F everything. And she said that in front of her teammates and says that right to a coach. Well, that'd be certainly subject to discipline. She's disrupting the practice. She's undermining the authority of the coach. She's being insubordinate to the coach. They could even be interpreted. I mean, kind of a stretch, but it could be interpreted as a threat. But now they're saying it off the school grounds, and they're saying it, they're just basically venting. Now, the Supreme Court kind of ducked the issue in that they didn't want to get into specific situations, and I think that's smart. They wanted to leave for future cases to decide where, when, and how these features, the speaker's off-campus location, will make the critical difference. But they do decide this case. So in other words, they didn't want to say, okay, well, here's the laundry list. Now, if a student says X, then they don't want to give kind of a menu. Okay, student says X, you discipline. Student says Y, hands off. Okay, if the student is doing this in their home, you discipline. If the student's doing this out, on a hiking trail, you don't discipline. They just basically wanted to say, okay, schools have the right to discipline for off-campus speech, but it's not unbridled. That you have to determine whether it really is going to cause essentially substantial disruption of the school. And really think about this. Now, maybe I'm being a little too, maybe I'm saying, giving insights into myself, but F school, F softball, F cheer, everything. I think many of us in our lives have had moments of anger or upset or despair where we're thinking, F this, F my job, F so-and-so, F this. And that's what this kid said. The fact that it was a kid, the court essentially said at one point, it's vulgar and inappropriate, but, and remember, there are no threats here. Now, if she had said, I am going to F up the school, if I'm going to F up the softball team, well, now it's completely different. Because now that's a reasonable interpretation that it's a threat. And that kind of goes into another dimension. Now, maybe, maybe they'll just say, well, it was just some stupid kid venting. in a very inarticulate fashion. But they're just basically saying F school. So let's go some of the considerations. One of the bottom lines of this First Amendment free speech jurisprudence, and I have litigated free speech cases in federal jury trials involving employees. Different kettle of fish, different considerations, different case law precedent. But one of the things that really apply to both the student and the employee is that, it kind of has to be on a matter of public concern. And public concern is kind of a flexible concept. It can be kind of generalized depending upon the concept, the context. And the fact that someone says something that's unpleasant or is a disagreement with, having to wear a mask in school, that's so lame. That's so stupid. Well, okay, they're disagreeing with the policy. You're not going to discipline for them for that. Now, if they don't wear their mask and refuse to wear it, well, that's a different situation. But this is the court said this is kind of the same type of situation. Put aside the vulgar language. Basically, they're criticizing the team's coaches in the school. The criticism of the rules of a community which BL forms a part. So essentially, that is of public interest because they're implicitly criticizing the process by which kids who go to this community's public school are selected for different teams. There are no threats of violence. So there are threats of violence, or in the alternative, what they call fighting words. I'm going to go kick his, backside, what have you. Those are not entitled to First Amendment protection. This didn't involve that. This was just kind of a venting of steam. Some other considerations. I'm sorry, it's supposed to be while BL used vulgarity. Her speech was not obscene, as the court has previously defined that term. I mean, obviously not the sort of language that typically one would use or would want to hear within a school day or from school students. Nonetheless, it is not obscene. Obscenity is something far more hardcore. And this sort of goes back to what I was saying before. How many people have not at some point said F everything? Because the court says BL uttered the kind of pure speech to which, were she an adult, the First Amendment would provide strong protection. Her post appeared outside school hours from a location outside school. That's not dispositive. As I said, the court did hold that the district could still discipline for that. But she did not identify the school in her post. She didn't target any member of the school community with vulgar or abusive language. She transmitted it to a private circle of Snapchat friends. Remember that prior case, the kid, again, who on his private Facebook account, vents his anger at his teacher in totally inappropriate way, but nonetheless. The fact that there's a possibility it's going to be transmitted to the school itself, nonetheless, the school's interest in punishing her is still diminished because of these features. The fact that, she's just basically blown off steam. She's not threatening anyone. She's not bullying anyone. She's not harassing anyone. It's not hate speech. She's not focusing at a class of people based on their race or religion, their disability or anything like that, their sexual orientation. It's just a knucklehead being a knucklehead, essentially. The knucklehead exception, which is not expressly stated in the decision, but that's essentially what it is. Some additional considerations. The school said, well, we're trying to teach good manners, and using, again, some of that prior language court cases. But the court said, well, yeah, with this anti-vulgarity interest is weakened by the fact that BL spoke outside the school on her own time. Essentially, what that boils down to, let's say, hey, Principal so-and-so, I was over at BL's house and she used the F word. Oh my God, she was throwing the F bombs around like there's no tomorrow. Oh, we're going to suspend her for that. Well, obviously that'd be ludicrous. There'd be no basis for that. Or hey, Principal so and so, over the weekend or over the school break, there was these, BL was outside. She was shouting, "Hey, get off my effing lawn!" to some kids in the neighborhood. Well, again, I mean, what's that got to do with the school? So that's what the court essentially is talking about through here. They're just speaking. Well, she spoke outside the school in her own time. As I said earlier, if it had been on the school grounds, well, that's and directed at like a school official. Well, that's different. Or someone's shouting profanities in the middle of the school day in like a hallway. Well, that's disruptive. People hear it say, "Hey, what's going on? What's the commotion?" But she didn't do that. She spoke into circumstances where the school did not stand in loco parentis. Now, again, we in the law like to use these Latin terms. And essentially that underscores the fact that when a kid is at school during the school day, the school is deemed to be in loco parentis. In other words, they stand in the shoes of the parents. And that's why they can monitor and regulate student behavior within the school. Well, here the kid's not in school. And she's not at a school sponsored activity. She's not at like a field trip. She's not at an overnight, visit to some, New York City or anything like that. That's organized by the school. She's not at a football game on the school grounds. And there's no interest. There's no indication that the BL's parents said to the school, "You have the right to regulate my child's behavior when my child is not in school." So there was no in loco parentis there. And also, the school has presented no evidence of any general effort to prevent students from using vulgarity outside the classroom. That again ties into what I said before. The school doesn't have this kind of free roaming right to police vulgarity. It's not like Mothers Against Drunk Driving, administrators against vulgar language. I mean, there's no such organization like that. So it wasn't contrary to the pedagogical interests of the school. I mean, the school didn't have some sort of great pedagogically based campaign to eliminate student vulgarity in all spheres. So, the court considered the school's claim that it's trying to prevent disruption within the classroom and the bounds of school-sponsored extracurricular activity. But again, you're shocked, you're stunned. What? The term substantial disruption appeared in this case? Yeah, exactly. No evidence of substantial disruption. You're going to leave this with two words in your mind: substantial disruption. And that's what the court is saying. There's no evidence of record of substantial disruption. They talked about it for 5 to 10 minutes in an algebra class. And, some the cheerleaders were upset about the content of BL Snapchats. Hey, she's saying F cheer. We're the cheer team. Hey, they're not being threatened. They're not being targeted. She's not establishing a MySpace website or putting it on YouTube to say, yeah, these gals are all whores. They're all this, they're all that, they're all this. She's not doing any of that. And in the course of this case proceeding up the judicial court chain, clearly there was an introduction of evidence. And one of the coaches was asked, well, was there any reason to think that this particular incident would disrupt class or school activities? And the coach, to his or her credit, responded, to their credit, responded honestly, no. So, you look at Tinker again. It must show that the action was caused by something more than a mere desire to avoid the discomfort and unpleasantness that always accompanies a popular viewpoint. So in other words, for school discipline, the school must show that the action was caused by something more than a mere desire to avoid discomfort and unpleasantness. There was a disruption of the educational process. There was lewd and vulgar talk in school grounds, like during a school speech. It was directly contrary to the pedagogical interests of the school. None of that is applicable here. So essentially, it was just that they didn't like what she said because it was unpopular, because it questioned how members of the softball team and the cheerleading team were selected. Okay, so the school presented some evidence of concern for team morale. There's negativity put out there that would impact students in the school. Give me a break. It's not as if people, had to go seek members of the cheer team or the softball team had to go get therapy because they, their self-esteem was seriously dented. There might have been some, well, they could have bummed me out. Well, something bums you out, that's not sufficient basis for suspending someone else for the expression of speech. As the court observed, simple, undifferentiated fear or apprehension is not enough to overcome the right to freedom of expression. So the fact that, people might not like me because she said something, she said F cheer, F softball. Well, again, that's different from being targeted, from being bullied, from being threatened. If no one could speak because it might upset somebody else, the court essentially held. And Justice Breyer, wrote something that was not quoted at all in any of the media reports, but which I thought was very significant. He went back to what Justice Oliver Wendell Holmes said, 100 or more years ago, in talking about a free speech case. There's a marketplace of ideas. He said, schools are an incubator for thought, for thinking, and for thought. And saying that, well, you can't say things, or you're going to be disciplined for saying things because other people might feel apprehensive or might not feel, their morale might be lessened. That's not enough to support and to justify violation of someone's free speech rights. There should be an encouragement of different viewpoints, and they should be used as pedagogical tools in which to say, okay, big mouth, what's your support for that position? Forcing people to think about it so that they can reject it on their own, essentially. So that was kind of the point of this case. So this is just kind of, I know we're running out of time. Oh, I guess we have like 1 minute left. So this is just kind of a synopsis of what we talked about. School districts may restrict the free speech rights in a more intrusive manner than society as a whole. Vulgar, lewd, indecent, or plainly offensive speech, reasonably related to legitimate educational concerns, and the key, substantial and material disruption. So some of the things you got to think about. How many students from the school viewed the postings? Did they include widely disseminated threats of specific violence? Did the consequences of the conduct carry over into the school? Or could it be, was there a material and substantial disruption of the educational process, or at least a reasonable expectation of such disruption? Does the post result in the victim contacting the school? Now, that's not dispositive, but that kind of is one of the constellation of facts that the administration has to weigh. That this is adversely affecting a student's ability to access their education. They're being cyberbullied, what have you. Was the victim afraid to come to school? And was there an obligation to contact the police and/or DCF? In other words, are there serious threats? Like the kid with the escalating violent messages and talking about the guns he has and how he's citing Virginia Tech and he's going to shoot specific people. Hello, call the police. And in the end, what I say, which conversation would you rather have? The one where you must justify why you intervened, or the one where you must apologize for why you did not? I think I'd rather have the former one than have to say, well, gee, we really didn't think it was going to come to that. But in any event, the takeaway too is that BL is essentially the appropriate culmination or the next sequential step in the Supreme Court jurisprudence on the school's ability to regulate off-campus speech. It can do so. It doesn't have an unbridled authority to do, unlimited authority to do so, but it does have the right to do so when it involves substantial disruption, threats of violence, which are kind of symptomatic of or part of the symptomology of substantial disruption. So your great relief, I'm going to stop talking now, unless anybody has any more questions.
Mike, you've done a super job, tons of fantastic information for our audience, and you made my job easy by answering the questions that came up during the presentation at the most relevant points. So I appreciate that, and I know our listeners
welcome.
appreciate it as well. So because we have pretty much run out of time, I want to thank you, Mike, of course, for being here to share your expertise with us. I want to thank again CAS's corporate partners, Buffalo Wild Wings, Connecticut Army National Guard, Connecticut Department of Public Health, Connecticut Lighting Centers, Horace Mann, Jostens Liberty Bank, and especially Mike, your law firm of Pullman and Comley, for the support that all these organizations give for professional development for Connecticut's school leaders. I want to thank our audience for being here today. I know this information will be valuable to you in supporting the important work you do in your schools. We will have the recording of today's webinar available in a few days, and you'll receive notification when it's ready. I hope you'll attend future CAS webinars and programs. Please visit our webpage at CAS-CIAC.org for details on all CAS events and activities, and check your weekly CAS news blast, which will be starting up again shortly. On behalf of all of us at CAS, have a great day, a great end of the week. Again, thank you for being here, and see you at our next webinar. Thanks, everybody.
Thank you. Take care.